The First Amendment is a very important part of the Bill of Rights, as you've previously said, and it says that Congress shall make no law respecting an establishment of religion or prohibiting its free exercise or abridging the freedom of speech or of the press. A very wide provision and something about which the United States is highly respected. Do you think the United States has gone too far in protecting free speech and not far enough in protecting religion?
Again, I think, as I said earlier, I think that the pendulum swings on these situations. I think currently, yes, I do think that perhaps religion has not been protected enough. And if someone has an objection to something, they shouldn't be forced to accept that employee or whatever those kind of situations are. I think free speech is right up there with the fundamental principles of America, like liberty is. I think it was Patrick Henry who said, give me liberty or give me death. And there are mottos, state mottos, even printed on license plates. Don't tread on me, one state. Liberty or death is another state, and so on. And I think freedom of speech is right up there, equally as important. And I think sometimes perhaps there's too much flexibility. For example, in libel laws, they're much more strict here and in the UK than they are in America. You can really say whatever you want to a pretty, unless it deals with obscenity or there's a few categories of felonies or fraud or those kinds of things. But other than that, freedom of speech is pretty wide open, and I think that's a good thing.
Yes, some American well-known people, including the wife of the president, have sued in London rather than the United States because of the libel law in London. Now, at the time of our federation, the American courts were still saying that the provision in the Constitution was no more than the common law. So Australians at that time wouldn't have thought, there in America they have much more freedom of speech than Australia. They didn't. In fact, during the Civil War, Lincoln used stringent powers, draconian powers, against the press. So there wasn't that same freedom that we know today. And in relation to religion, again, there was a difference because the reason why that provision's there, I think, is that some states had state religions at the time of independence. Many of the American states were founded for religious reasons, and the Plymouth Brethren are the famous part. So many people left England because they were dissident Protestants who for some reason found going occasionally to a Church of England church so horrific that they crossed the Atlantic in little ships because of the horror of going to a Church of England church, because that was the state religion in England and they didn't recognize other religions, although they existed. And what they didn't want was the federal government establishing a federal religion. And they wanted to continue to have their state religions. And I think that was there more to stop the federal government from abusing powers, particularly the Congress, rather than worrying too much about freedom of speech to the degree that it exists now in the United States. I agree with you, the libel law has gone too far. If you are a public figure, it's almost impossible to sue. People can say anything they want about you. The standard has been changed so that you have to prove that the newspaper knew that what they were publishing was either untrue or they were recklessly indifferent as to whether it were true or false. You can't prove that. You can't prove.
Yeah.
And so public figures don't sue. But that boy who was attacked because he was wearing a MAGA cap.
In Washington at a protest?
Yes.
With the Native American guy?
Yes.
Yes.
And he was highly criticized by the media. He would have succeeded, but for the fact that all the cases were settled, because I don't think it could have been said that he was in any way a public figure, even though he was wearing a Make America Great Again cap. But these are very few. It's rare that a person who's not a public figure is defamed by the press or other people. They wait till you're a public figure before you're defamed. You may be a criminal or a celebrity or a politician, and then you're defamed, but not before, because you're unknown, so you don't get into the news. But you feel that they've gone a little too far in protecting speech and not far enough in protecting religion.
I do think that, and I'm not a religious person, but I do think that. I think that one of the key principles of that amendment is no establishment of state religion, of course, or federal religion, but allowing people to practice what religion they would like to. And I don't think they should be forced to do things that they feel are against the principles of their religion.
Until a few years ago, a vast part of defamation cases were brought by politicians to stop the public discussion of highly relevant matters. And it did have that effect. Issuing a writ did kill the debate. And that was a bad thing. They then reformed the defamation law. It seems to have done away with that. We still have a large number of defamation cases, but usually brought by private litigants rather than politicians. Politicians seem to have given up suing for defamation. But I agree with you. I think there should be more freedom in relation to matters of political interest. And I think that there should be a defence in Australia that if it is fundamentally a matter of political interest, that there should be a greater freedom to speak on those.
I don't know if we agree on that point necessarily, because I think that there's a very clear separation of church and state that's been interpreted in the Constitution. And I don't think that religious organizations, if you are a charitable organization and you're not paying tax as a church or a ministry or whatever that is, that you should be able to go and participate more in politics. I think that on that particular point, I think that separation of church and state should be kept separate.
Even to the extent of banning prayers in public places or religious symbols in public places?
Well, it depends. It depends on the context there. I think there was a very controversial case, it was maybe 5 or 10 years ago. I'm sure you've read about it. There was a Supreme Court justice, a state Supreme Court justice of Mississippi or somewhere, and he had a large carving in front of his courthouse in the grass that had the 10 Commandments on it. I have no problem with people who want to practice the 10 Commandments or rehearse them or teach them in religious gatherings and all those kinds of things. But it's pretty clear that as a Chief Justice, that would be promoting religion, and that clearly, it was ruled that it was clearly violating that principle of separation.
It was eccentric too.
It was.
But you have no objection to "In God We Trust" or something like that?
Oh, no, of course not. No.
Or public prayers? For example,
like
in
a school, if they're required to take part, if it's a religious school and it's then of course I think that should be allowed. If it's a public funded school, I think that I have no problem with people if they wanted to pray or if they wanted to do whatever sort of religious practice. I don't think it should be required of all students to participate in something like that.
In this state, all schools were religious.
Here?
In New South Wales in the 19th century, when compulsory education was brought in, the state took over the religious schools by agreement with the religions. These were the parish schools. All religions agreed to have, they kept some of their prestige schools or created ones. All religions agreed except the Catholic Church, because they wanted children to have a Catholic education. So everybody else got free education, but not the Catholics, which seemed unfair. But in the state schools, part of the agreement with the Protestant churches was that they would allow scripture, that is, periods of religious teaching, I think 1 hour a week, where the religions would come in and the children who belonged to the Methodists or so on would have religious education. I suspect that might be thought to be in breach of this in an American public school. But this has been tested in Australia. We have a provision about not having binding religious requirements. But the High Court has said that this is consistent with that. But in America, you wouldn't be allowed to have children going to religious education for a period in a public school.
And in a public school, not anymore. I think that not probably for the last 40 years, that's probably been abandoned.